We have Mr. Yoder present.
Your Honor, he's lodged in the Webster County Jail. I do have one other person here, Mr. Sherwood. This is Mr. Yoder.
Okay. All right, Mr. Yoder, are you able to hear me okay?
Yes, sir.
If I could have counsel for your appearances on.
Brian Ziegler,
Tom Seeger appearing with on behalf of Mr. Sherwood.
Seeger, can you tell me the status of this file?
Your Honor, it's my understanding that the people have offered Mr. Sherwood an opportunity to break down the attempted resistance of structure. All of the counts.
Mr. Ziegler.
fair statement, Your Honor.
Mr. Sherwood, have you had an adequate opportunity to speak with Mr. Seeger about this plea agreement?
A little bit.
Would you like?
Showed up a little bit late.
Okay. Would you like some more time to do that before we go forward?
No. Okay.
Did you want to proceed with that plea agreement here today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Sherwood, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to attempted resisting or obstructing, maximum possible penalty you could face would be up to 1 year in jail and or a $1,000 fine.
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
I do.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty to this charge because you are guilty?
I am.
The information I have indicates this happened back on November 11th of 2025. Is that the correct date?
Yes.
And on that date, did you come into contact with a Deputy Hawkins or Deputy Beaver here from the Kalkaska County Sheriff's Department?
Yes.
Did that encounter occur somewhere here within Kalkaska County?
Yes.
All right, and what happened that would make you guilty of attempted resisting or obstructing?
I did not leave the scene when prompted to. I was given an opportunity to leave the scene, dealing with my son at the time, and we had an altercation, but he has since been evicted from the house, and I don't know where he's at now.
Okay, so they were there investigating an altercation between you and your son?
Yes.
And as part of that investigation, ordered you to leave that premises? Okay. And were they doing that to try and separate the two of you, or?
I do believe so.
Okay. And you said that you didn't follow that direction?
No, sir. I wanted them to deal with his problem. I'd caught him previously using methamphetamines in my mom's house. So I attempted to deal with it myself and did not do it right.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, Your Honor. Your Honor, additionally, people don't have an objection to immediate sentencing unless the court wishes to have a formal pre-sentence report.
Okay. Mr. Ziegler, any objection to going forward with sentencing here today?
No, Your Honor.
Okay. Before we get to that point, all right, are you both satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
Yes, sir.
Okay, so Mr. Sherwood, the court finds your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of attempted resisting or obstructing. The court will accept the plea. Your lawyers indicated that we could move forward with sentencing here today. You do have the right to have a pre-sentence report prepared and have this set on a separate date. But do you have any objection to going forward here today?
No, sir.
Okay. Mr. Ziegler, are you going to be asking the court to impose any jail time as part of the sentence?
No, Your Honor.
Okay. Is there anything that you wanted to say then for allocation?
Your Honor, this is a circumstance where officers responding to a alleged domestic violence situation. Mr. Sherwood was intoxicated. He seemed to want to comply with the officer's commands to stay separate. At some point, they decided to place him into handcuffs. He did not want to comply with that either. They gave him several commands. He refused to follow those. They eventually had to physically grab his arms and force him to the ground, at which point he complied with the handcuffing. I don't believe anyone was injured as a result of that. Mr. Sherwood has not been in any trouble in about 9 years. He does have a few misdemeanors on his record in the state of Michigan, no felony history. I do think that this was just a very poor decision by Mr. Sherwood. He was intoxicated and he did not handle the situation appropriately. But given his lack of history in the past 9 years, I don't see that there's any point to jail or probation under these circumstances. I'm just hopeful Mr. Sherwood has learned his lesson from this incident and hopefully will handle things better in the future. I think a sentence of fines and costs is sufficient at this time. Thank you.
Thank you, Mr. Seeger.
Yeah, likewise, I would just ask the court to consider limiting this to full cost and fines. I know Mr. Sherwood from, I think his life has changed significantly. He was going through a hard moment. Clearly, he should have listened to law enforcement. Quite honestly, Your Honor, and he'll acknowledge this, that there was a moment where he could have left and it would have been nothing. Instead, he chose to continue to have a disagreement with law enforcement, which he should have just left. But he didn't. Instead, but to that end, Your Honor, he's generally done well. Sorry that this has all happened. He had expressed to me that he was trying to address a substance abuse problem with his son. It clearly didn't go very well. But again, when law enforcement are there, it would be much better to follow the commands of law enforcement. Should he ever pick up a felony somewhere in the future, hopefully that's not the case. This conviction allows them to habitualize him. So hopefully this is a learning lesson for him. But given that there's been a great amount of time that has elapsed since his last conviction, I assume that he's not likely to come back. He did indicate that he just wishes to put this behind himself, and he said that.
Thank you, Mr. Sherwood. Anything you wanted to say today?
No, Your Honor.
Okay. All right, based on what I've heard, I think the recommendation of fines and costs is appropriate. Mr. Sherwood, obviously, there's a number of ways that the court can punish wrongful conduct. One of those ways is through incarceration. Another way, though, is through financial penalties, which sometimes can be just as punitive as a jail sentence. And in this case, based on what the lawyers have had to say about this incident, while your actions certainly exhibited poor judgment under the circumstances, which I'm sure wasn't helped if you had been drinking at the time, I don't find that the circumstances call for a jail sentence. So I agree again with the imposition of fines and costs as a way to impose a penalty here. So the court is, because this is reduced to a misdemeanor per the plea agreement, the court is going to assess a crime victim's assessment of $70, a state cost of $50. Are you appointed in this case, Mr. Seeger?
I was, Your
Court costs of $325, attorney fees of $350, and a $100 fine. You do have the ability to seek an appeal of the sentence, Mr. Sherwood. If you wanted to do that, you would need to file that paperwork within the next 21 days. If you have more questions about that part of it, you could ask Mr. Seeger and he'd be happy to explain that process to you. Otherwise, I just need you, after leaving court today, to go next door to the clerk's office and set up a plan for paying those fines and costs. Do you have any questions at all?
No, Your Honor.
Okay. Thank you. That's all for today. Good luck going forward.
Thank you, sir. I'll follow right through.
Ms. Chisholm, if you can go right to the podium there for me, please. Okay. On the record and People versus Jasmine Chisholm, this is file number 255123. The record should reflect that Ms. Chisholm's present here in the courtroom today. You have counsel put your appearances on.
Ryan Ziegler, on behalf of the people.
Kyle Travis on behalf of Mr. Jones.
All right, this is the date and time set for sentencing in this matter. Ms. Chisholm, did you have an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, I did.
And Mr. Travis, are there any additions, deletions, or corrections to that report? I did get the memo regarding the HYTA.
Yes, thank you, Aaron. I guess two issues. One, in the memo regarding HYTA, I misstated the recommendation. It is not a recommendation for credit for time served at 99 days. It is actually, I believe, my interpretation is a recommendation for 6 months in jail. Also, Ms. Chisholm did note on under family, it lists her father, Johnny Chisholm. It looks 6395 Cram Road. That is actually apparently her grandfather's address, who is a senior of Mr. Chisholm, so not an uncommon that they get confused. And I don't know if it's super essential to the report, but that's her grandfather's address, not her father's address.
Okay, so we'll strike the address then. Any other changes?
No, Your Honor.
Okay. Any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No.
Okay. I should note that there was a victim's impact statement that was attached to the PSI. Did have an opportunity to review that as well. Anything on behalf of the people for allocution?
Your Honor, I think the recommendation in this matter is appropriate. I'd ask the court to adopt it. The recommendation calls for 6 months of jail followed by 2 years of probation. I think the jail recommendation is appropriate primarily because of the nature of the offense. This was a serious crime where the victim was stabbed in the back with a knife and he was hospitalized for several days as a result of that injury. To top that off, when Ms. Chisholm was arrested, she bit one of the troopers involved, causing him a minor injury to his finger as well. Jail punishment is clearly warranted on those facts alone. I also think the term of probation is warranted. I'd ask the court to adopt that as well. It's clear the defendant is a young person. She has the time and the ability to reform, and she's dealing with some combination of either alcohol abuse and or mental health issues. And extended monitoring by the court is appropriate, both to provide her resources to deal with those issues and to ensure she does not engage in similar behavior like this in the future. So I think the recommendation contained in the report makes perfect sense to me, Your Honor. I'd ask the court to adopt it.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, a couple things. As noted, and I think Your Honor took this as a no contest plea, Ms. Chisholm was rather intoxicated when this happened. She has expressed a desire to attend rehab. If Your Honor were to follow the recommendation, I would ask the court to consider allowing her to the opportunity, if she could get in, to do a day-for-day credit towards the end of that sentence to go to a rehab. Albeit not an inappropriate recommendation, the recommendation for basically a guidelines max and probation, I would say is not the most common, totally legally permissible, obviously, but so if the court is inclined to place her on probation, I would come back to my memo relative to the HYTA. I don't really see a harm in that, and it would be a great benefit to Ms. Chisholm and potentially a benefit to the community. I do think, and she knows she has a problem with alcohol, which is unfortunate. She had come to the court at 19 today. She was actually 18 when this occurred. She had her 19th birthday while incarcerated. She has been incarcerated for a little over 3 months already, so there has been a jail term. She's never been incarcerated before, so all of this is having an effect on her. I know she's quite remorseful about what happened. from what I've learned about her living situation and that situation, it was not good to say the least. It's noted that she's not employed and wasn't working. That's one thing I've talked with her about, that I'm quite hopeful that she comes out the other side of this, potentially able to support herself and not feeling as though she needs to depend or get involved with, older men who feed her liquor. There's a lot of potential upside here for Miss Chisholm. She's young. She has no criminal history other than this. She can move forward and have a wonderful life, or she can go further down the path of substance abuse problems and destructive relationships. She's knows that. She's, remorseful about what happened. She believes that had she not been intoxicated, she would not have responded to this situation that way. It's probably completely accurate. So I'm quite hopeful that she can turn a very bad situation for a young person and for Mr. Yoder. Obviously, nobody deserves to be stabbed, no matter the circumstances, really. And it was quite serious. And she's quite remorseful about that. But I'm hopeful she can come out of this in a better situation as a young person, because she is quite young. Thank you, Your Honor.
All right, thank you. Ms. Chisholm, anything that you wanted to say today?
Yes, please, and thank you. I would like to apologize to the court. So my irresponsible actions that I have done, I know that I am 18 years old and I'm still an adult. I should have told myself no to the alcohol, and because I fell into the addiction, I have harmed 2 innocent people, and I'm hoping that the officer is doing well and did not get sick or any other harm to his hand. And I hope that Mr. Yoder, my former partner, is breathing and he's doing well with his health. I really am sorry.
So I read through the report. I'm familiar with what happened in this case. Also, just your background, your circumstances and so forth, based on the information in that report, as well as what the lawyers have had to say and what you've had to say. I will say you appear to be genuinely remorseful to me here, and that's a good thing. That means that you recognize this is not conduct that's acceptable. In terms of an appropriate sentence here, I think the court has to look at 2 things. Number one, the seriousness of the conduct that you engaged in. However it happened, being intoxicated to the point where you don't really remember what happened and probably didn't have control over your actions, conscious control at least. The harm that was caused, I mean, we had an individual that was injured seriously enough that they had to stay in the hospital. And actions and an injury which could have been much more serious than they were. If you had hit, an artery or a vein or something where they couldn't stop the bleeding, this person could have died from this injury. So incredibly serious conduct, and concerning conduct. But I think I also have to look at the rehabilitation aspect of this, because you are now 19. You have very little life experience at this point, and you've got a lot to go ahead of you. And so I think given your lack of having been in any kind of trouble before this, gives the court some reason to believe that if you can get some help and get some treatment through a course of probation, that you could move forward from this and be a productive member of our community, not be somebody who's causing trouble, but somebody who is being a positive influence in the community. So I think a sentence that combines those 2 things is called for here. I think given the seriousness of your conduct towards both of the victims in this case, I think calls for a 6-month jail sentence, I think is absolutely reasonable and fair. I think a longer sentence probably could be justified given the seriousness of your conduct and the potential harm that could have resulted and the harm that did result. I also think that probation is appropriate to monitor you to make sure you get yourself on the right track, and that you stay on the right track. I think allowing that probation to the extent you're eligible to be pursuant to HYTA, I think is fair. It gives you an opportunity as somebody who's 19 to have this come off your public record if you are able to be successful on probation. And there's really no risk to the court or the community in giving you that opportunity, because if you don't follow through with it, you'll lose that HYTA status and this will remain on your record. If you do, it'll give you an opportunity to move forward, have employment and other opportunities, and not have that hampered. So I think that sentence provides an appropriate degree of punishment given your age and the circumstances, but also allows for the rehabilitative aspect of this. So the court is going to sentence you to 6 months in the Kalkaska County Jail. You do have credit for 99 days served. The court, and this is as to both counts, the court is going to place you on probation for a period of 2 years pursuant to HYTA. The court is going to adopt as the terms and conditions of your probation all of the terms and conditions listed in the report. That includes completing any outpatient or residential substance abuse treatment once you're released from jail, completing any mental health or domestic violence intervention or other treatment or counseling that's recommended to you, not having verbal, written, electronic, or physical contact with Daniel Yoder, either directly or through another person, or be within 500 feet of his residence, school, or place of employment, not using or possessing any objects as weapons, not engaging in any assaultive, abusive, or threatening or intimidating behavior, not using or possessing any alcoholic beverages or other intoxicants, along with the other provisions which your agent is going to go through with you. The court is going to order a crime victim's assessment of $130, a supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a state cost of $118. You do have the ability to seek an appeal of the sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with that appeal. And Mr. Travis, if you can have Ms. Chisholm acknowledge receiving those appellate rights, please. Good luck to you going forward, Mr. Trump.
Thank you, Your Honor.
Versus Larry Flowers, case number 255115. Record should reflect Mr. Flowers is present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler, on behalf of the Honor.
Kyle Travis on behalf of Mr. Flowers.
This is the date and time set for sentencing in this matter. Mr. Flowers, have you had an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yeah, yes, I'm sorry.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Not anymore, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, this was a plea that was reached between the parties as sort of a pseudo 7411 agreement. It was amusing to myself and Mr. Travis that even though we believe that he has a conviction for possession of marijuana that was expunged, it doesn't appear in the PSI, but we do believe he has that conviction, and we do believe it does make him ineligible for 7411. But I think other than that, Mr. Flowers is very likely to do well on probation. He has no other criminal history that we're aware of. I think that makes him a good candidate to successfully complete the terms of his delay, and I hope he takes full advantage of those terms.
Mr. Travis?
Thank you, Your Honor. Yes, I think the PSI very much makes the argument that the delay that Mr. Ziegler offered and that Your Honor accepted it is appropriate in this case. Mr. Flowers has had some troubles as of late, as indicated in the report. He's moving forward with that. Got to take more notes, got to plan the day out better. But he's doing well. I think he will do well in this probation. He's taking it seriously. He's motivated to do well. So we would ask Your Honor to follow the recommendation.
Flowers, anything you wanted to say?
I'd just like to acknowledge that I know what I did was wrong. I had up my butt, for lack of a better term. I would also like to thank the prosecution for drawing out, finding a better sentence or sentencing for me, so I did not qualify for the 7411. I appreciate that. I just want to move forward from this and everybody's here.
All right. Well, I hope that's the way it goes. That's what we're all hoping, I think. And you're gonna have an opportunity to do that through this delay of sentence. And I think under the circumstances here, the lawyers have indicated the reasons why, and I agree that it is an appropriate resolution. It's going to give you an opportunity to avoid any kind of jail time in this case. And if you're not successful, I'm sure Mr. Travis has gone through the guidelines with you. There's a potential of up to 6 months in jail. So I hope that provides an additional motivation to you to comply. So the court is going to follow the recommendation in the agreement and put you on a delay of sentence for 12 months. The court is going to adopt as the conditions of that delay all the terms and conditions listed in the report, and that includes not using or possessing any controlled substances unless they're prescribed to you by a physician, as well as all the other terms and conditions which your agent will go through with you. In order to get the benefit of the delay here, you'll need to, before it's over, you'll need to pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost, along with a fee of $30 per month during the delay for supervision. The court isn't going to address any jail time or jail credit at this point, given that this is a delay. So Mr. Flowers, it's very important that you go through this with your agent. Ms. Wagner, I know Mr. McFalda is the one who did the PSI. Are you going to be the supervising agent here?
Yes, if he can come over to the office, I'll get him set up with reporting instructions. Thank you.
Okay, so just check in with Ms. Wagner before you leave here today. And, again, it's very important to stay in touch with her and make sure that you're complying with all the terms, okay?
Good.
Do you have any questions at all?
No, sir.
Okay, good luck going forward. Thank you.
Thank you.
Thank you, Your Honor.
Mr. Williams, were you ready with Ms. Green's case?
I am, Your Honor.
People versus Heather Green, file number 255053. The record should reflect Ms. Green's present here in the courtroom today. If counsel can take your
Jesse was signed this week.
This is the date and time set for sentencing in this matter. Ms. Green, have you had an adequate opportunity to go through the report with Mr. Williams? Mr. Williams, are there any additions, deletions, or corrections?
No, Your Honor.
And are there, this is the one you're misdemeanor, no guidelines. Mr. Ziegler, do the people have any additions, deletions, or corrections?
Yes, Your Honor, on page 2 and page 4 in the recommendation narratives regarding the restitution. At both those places, it says that the restitution is payable to the state of Michigan. It's somewhat of a moot point because the restitution's been paid in advance, but that's not accurate. $15,808.50 of that was payable to the Social Security Administration at the federal level, and the remaining $4,899 was payable to the state of Michigan. So it was payable to the state of Michigan and the Social Security Administration.
All right, thank you. We'll make that correction. Any other corrections?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I think the recommendation in this case of a brief, straight jail sentence is probably a fair and appropriate outcome. Ms. Green claimed benefits she was not entitled to from multiple different government agencies, state and federal, to the tune of over $20,000. This was not an isolated incident or an accident. She repeatedly told the Department of Health and Human Services that her daughter was residing with her when she knew that her daughter was in an alternate placement, and she was provided very little in terms of her actual care. Later, she applied for Social Security benefits and for RSDI benefits on her daughter's behalf. She forged her daughter's signature, and she did not provide any of those benefits to her daughter. To her credit, however, she's made full restitution to the government for these overpayments. I did receive checks from the defense about 3 weeks ago, and I've dispersed those to the relevant agencies. So all of the restitution is paid in full at this time. I don't believe probation is necessary or appropriate under these circumstances. There's no need to monitor her payments, and there's very little to be gained from her regularly checking in with the state. She's either learned a lesson from all of this and she's not going to do it again, or she has not, and probation's unlikely to change that either way. However, I do think some punishment is warranted to let others in the community know that you can't simply defraud the government and then skate entirely if you pay that money back later. I'm sure this has been a long and difficult process for Ms. Green, but I think a jail sentence is warranted in this case, Your Honor, if for no other reason than simply to deter other members in the community who would consider engaging in similar actions. The fraud at issue was significant, but she has no prior history and she's made full restitution. I think a sentence of 30 days is a reasonable balance given all of that, Your Honor. So that's what I would ask the court to impose.
Thank you, Mr. Williams.
Your Honor, may I approach? I just have 2 short letters that were
Yes.
provided today. I did present them.
Thank you. Did you want these back? Sure. All right, Williams and Tenney. And then anything for allocation.
Thank you. All right. I mean, I don't know about people defrauding the government and skating. It's a wild world we live in these days, but the family's always complicated, always layered. She's taking care of one family member. She's got a disabled other family member. She paid everything back in full. I don't believe that putting her in jail, the recommendation, I believe, was 9 days, but incarcerating her certainly is not going to deter the next person who is financially strapped and juggling different family members with different problems. That is that she was out vacationing and living some luxurious life at the government's expense, flying around on airplanes and other things. I agree that probation doesn't make sense. She comes before the court with no record whatsoever. She's a primary care provider for her mother, and she's making ends meet in life. I would just ask the court to censor fines and costs at this time. I really don't believe that incarcerating her will deter anyone in this similar circumstance, nor do I believe it serves any purpose to her. I mean, this case has been going on for some time. We've adjourned it so she can make this money back, and now just to put her in jail, that doesn't make sense. If we look at how a felony is treated, just statutorily, she's in a presumptive no jail sanction. And she's, it's a misdemeanor, but 0 to 18 months is presumed no jail. So just to incarcerate her, just to punish her, I really don't see how that's a value to anyone at this point. So I would ask you to censor fines and costs, Your Honor.
All right, thank you, Ms. Green. Anything that you wanted to say? Okay. All right, Ms. Green, I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your circumstances and your background. I take all of that into consideration along with what the lawyers had to say here today. And looking at these circumstances as a whole, I think sometimes people fall into this trap where they see a way that they might be able to get some extra funds. And I think a lot of people are legitimately in need of money. And I think they tend to engage in these kind of crimes when they don't think that this is going to get found out. In other words, that the bureaucracy is just so big with all the cogs and the wheels that it's just not something that's going to be discovered. And so I think that's an added temptation between the needs that they may have and the thought that this is money that they could get a hold of without any repercussions. And from what I read, I think that's what happened in this case. It may not be, but from what I read, that's what it looks like to me. You don't have any prior history. You did make efforts to repay all of the money. I think those are both factors that work in your favor. Obviously, your conduct in this case is something that works against you and that the court finds is something that requires the imposition of some type of punishment. In this case, and in every case, the court has at its discretion the ability to impose jail time as a punishment. Financial punishments are also an option that the court has to employ when it finds that jail time isn't appropriate. In this particular case, the recommendation is for 10 days. The prosecutor is asking the court to impose 30 days. Your attorney is asking the court not to impose any jail time. And in my view, I think a short jail sentence is appropriate in this case. For somebody that's never been to jail before, which I don't think you have based on the information here, it can be a very significant experience that I think would impress upon you that this is not appropriate conduct. And I don't think it needs to be a 30-day jail sentence. I think for somebody that hasn't been to jail before, a shorter sentence can drive that message home. And I think it is something that's necessary in this case, given the amount of money and the circumstances that there be this punishment. I do think it does serve as a deterrent if people know that it isn't a situation where you just pay back the money and everybody goes on their way. So for those reasons, I do find that a jail sentence is appropriate. The court is going to send you to 14 days in the Kalkaska County Jail. You do have credit for 1 day served. The court is going to order restitution, but that's already been satisfied. The court is going to order a crime victims assessment of $75, court costs of $325, a DNA testing fee of $60, and a $53 state cost. You do have the ability to seek an appeal of this sentence. If you wanted to appeal this sentence, you would need to file for that appeal within the next 21 days. If you have additional questions about that, then you could ask Mr. Williams. I'm sure he would be able to explain that process to you. Otherwise, you are going to be remanded to the custody of the county at this time. Mr. Ziegler, anything further on this file today?
There you go.
Mr. Williams?
No, sir.
Okay, thank you. That's all for this.